General Introduction to Discovery When You're Sued for Debt. Brought to you by Kenneth Chabert at yourlegalagot.com. Your advantage if you're being sued by debt collectors. There are two kinds of discovery, theirs and yours. That's pretty basic, I know, but we'll discuss them separately. We'll start with their discovery, although all my customers know that I suggest strongly that you should be the first party to serve discovery. But we'll start with theirs. You'll probably receive three things from them: interrogatories, requests for production of documents, and requests for admissions. Later, you may get a notice of deposition. You can look up all these things in your rules of civil procedure because each one has its own special rules. Interrogatories are questions, but they are not normal questions. If you look at the forms in the form book, you'll see what I mean. Interrogatories normally ask you to reveal lots of information. Lots. And they want it put in a certain order. Some of it they'll be entitled to, but others of it they're not. We'll talk about objections in a minute. Requests for production normally ask for documents, although they could include photographs and, other things too. Again, the requests are normally quite broad. We'll talk about objections to them too, along with the objections to interrogatories. Requests for admissions, on the other hand, are very narrow. They normally ask you to admit a specific fact, just one fact at a time. So you could get between 5 and 50 requests for admissions, or even more. The main trick to requests for admissions is that if you don't deny them within a time period established by the rules of civil procedure, they are taken as admitted. So you have to deny them within the time period. That's crucial. If you miss the time period, you'll probably receive a motion for summary judgment and could lose your case in a hurry. Of course, you can ask the court to let you deny them then, and usually you will get to. So if it happens, give it a shot. But I'm suggesting you not let it happen because you're not guaranteed to be able to give answers if you miss the deadline, and sometimes the court won't let you. You're not swearing to your answers on requests for admissions. Denials are not evidence, so you won't likely be cross-examined on them. The penalty for denying requests for admissions without a good reason is that you might have to pay the other side its attorney's fees for proving the stuff you denied. I've never actually seen that happen, but I'm sure it could, so you always want to have at least some sort of reason. The reason could be you don't know for sure, or that it's wrong, or whatever. You don't give your reason, though, in your responses. Instead, in answering requests for admission, you just say admit, deny, or object. If you object, you say why. So for requests for admissions, the objections will usually be that they are confusing or vague if the requests are not crystal clear. And remember I said that a specific request for admission can only be for one thing. If it's not, then you can object as compound, which means if there's more than one part. Your admissions, or their requests rather, should, according to the rules, be for one fact each, and you would only admit them if you're absolutely sure. And even then, my clients usually didn't. We'd just take our chances on not having to pay later. Understand that this is not legal advice or suggesting that you do any particular thing. I can't give you legal advice, so you'll have to take a look at the rules and make up your own mind as to what to do. Now let's look at interrogatories. For interrogatories, go back and look at the sample interrogatories I gave you for them and for you. And the ones for them have sample responses. That will give you some of the language used for objections. In general, sometimes interrogatories are confusing, and one should never answer them if confused by the question. Because for interrogatories, you will swear that your answers are true. They do matter a lot. You can be cross-examined on them, and you're bound by them. Therefore, one should never say something that they're not sure about. So if they ask you if the statement that they show you is true, or to point out any parts that may not be true, you could say that it is accurate if you know absolutely that the statement they are showing you is for an account of yours and that every single charge on there was true. You could know that. But maybe you don't. And if you don't, you say, I don't know, in order to be truthful. If you do know, it's lying to say you don't know. If you don't know, it's lying to say that you do. Be very rigorous was what I always suggested to my clients. Saying that you don't know something on interrogatories may keep you from denying it at trial, but it is not normally evidence that the thing is true. An objection to interrogatories might well be that they ask intrusive or oppressive questions. The test for discovery is that the question must be reasonably calculated to lead to the discovery of admissible evidence. And whether you are divorced or working or lots of things don't really cast any light on whether you owe this debt collector any amount of money. You have to figure it out for yourself. Debt collection actions are usually very simple. If they can show that you owe them money, then you owe it, and it doesn't matter if you lost your job or have excellent excuses for not paying it, unless there are defenses. The flip side of this is that questions going beyond issues like that are or can be unduly intrusive. Another objection to interrogatories is that they may be vague, confusing, or some variation of "you can't understand them." Can you answer a question you don't understand? You could object as vague instead. Remember that you're swearing to your answers. You can't be sure if you don't understand the question. The way you swear is by signing an affidavit which says everything that you say is true. You sign that in the presence of a notary public, which you can do for free at your bank or for money if you look one up who isn't in your bank. Some people are naturally pleasers, and they want to answer the interrogatory even if they don't understand it. They'll make up what they think it says, and they'll answer that. These people often get smeared in court. If you try to answer what you don't understand, you might get creamed too. And saying yes without it being absolutely true, or without your absolutely knowing that it is true, is another good way to get creamed. This video is continued. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well, so use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms, and defend yourself from the debt collectors.